This is the difference between administration versus probate. With administration, a person passes away with no will. It's a process in the surrogate's court. You typically hire an attorney to prove the facts and circumstances surrounding the person's death. Who survived that person? There are affidavits that need to be provided. We have to provide a copy of the paid funeral bill because that's a creditor, right? Whoever paid for the funeral. And it also helps prove to the court the facts and circumstances. Typically, the person who paid for the funeral bill, although not always, is the person petitioning for administration. The statute also provides for an order of precedence. Probate is a similar process, actually, but it means you had a will, and you have to get that will through the surrogate's court as well. You have to prove its authenticity, that it wasn't signed under duress, and it has to be, signed with proper formalities of execution. Witnesses have an affidavit submitted either with the will or post-execution. The testamentary capacity has to be proven to the court, and sometimes affidavits are required as well. So really, what's the difference? Probates are supposed to be quicker, and sometimes they are, but sometimes they're not. Probates are supposed to be cheaper, and sometimes they are, and sometimes they're not, depending on, whether or not there are disputes and things like that. And I think one key difference is with administration, the court typically requires a bond so that the estate is properly distributed and paid out and creditors are not defrauded. But in certain circumstances, the bond can also be waived. So essentially, both processes are court-driven and take time and money. So you should just probably do a trust to avoid either of those.